Okay, so let's start this drop in and learn session, and we'd like to welcome you all for being here today, and thank you also for taking time out of your schedules. It's interesting, we had a really good turnout today in terms of registrations, and we have people attending from not just North America but also Europe and even further afield. It looks like we've got a few people that have signed up and are attending from Africa. So to those of you that are in your evening and your nighttime right now, we'd like to thank you for being here live with us. Now, we are running a poll right now to see how many people have actually attended court and presented evidence in court. My guest today is Julie Tillotson. Julie is a criminal intelligence analyst, currently employed with a police department. And one of the things that we're going to say a number of times as we move through today's program is what we're doing here today is really presenting you with some ideas for best practices, some things that you want to consider. What we are not doing is we are not providing you with legal advice and or policy advice. So compliance with legislation that affects you in your jurisdiction, in addition to compliance with your policies, will ultimately be your responsibility, the responsibility of the investigators. So first of all, thank you, Julie, for being here today.
Thank you for having me.
So tell me, now you and I have known each other for quite some time, and one of the things that struck me when we very first met is you stated very clearly that your passion in your job is catching killers. Tell me a little bit more about that and the kind of work that you're doing.
Within my police agency, I've had the great opportunity to work with some really wonderful investigators who have brought me into a variety of different types of investigations, but probably the ones that I have the most experience with and the most interest in is really working with homicides, missing persons, things of those nature.
For just a second.
Yeah, I find that there's something very rewarding in being able to assist an investigator with those types of files. All files are important, don't get me wrong, but yeah, homicides are definitely my area that I like to work in.
Now, one of the things that often strikes me in working in the police world as well is that the difference in the mindset between an investigator and an analyst. There is a slightly different mindset there. I mean, both working towards the same common goal, but a slightly different mindset. What is your observation, having worked in policing now for a number of years, about the difference in that mindset? And maybe as well, if you could maybe talk about your educational background prior to coming into policing as well, and how that has assisted you.
Yeah, so prior to working with the police, I was teaching at the university, a couple of different universities, and sociology, criminology, youth justice, those types of courses. And so when I came to my police agency, I was able to really bring forward a lot of that same academic rigor, integrity, looking for a full picture, big picture. I try not to be strictly driven only by small details within a file. I try to look at a much bigger picture. Oftentimes in my organization, an analyst is one of the few people in the file that are going to read every single piece of paper, read every statement, view all of the information. There's a couple other people in the investigation that also do that, but an analyst really is starting at page 1 and flipping through that whole book to see what all is going on in that file. And whereas my organization, investigators are often kind of given pieces to work on. So yeah, having that ability to look at the entire file from beginning to end, every piece of paper, it really allows me to have a much bigger focus, I guess, to some degree.
Tell me about the implementation of open source intelligence into an investigation. So let's say, for example, we've got a murder investigation. There is going to be witness statements. There's going to be evidence that has been recovered from crime scenes as well. And now we've got this open source intelligence component as well. How has that played a role in some of the investigations that you've been involved in?
Well, I can't talk about anything current, obviously, but previously what open source has allowed us to do is match nicknames. For example, we may interview somebody involved in the murder, and they'll say, oh, well, and so was involved, and give us a nickname. And oftentimes that might be the only name they know. So for us to be able to use open source to try and figure out who might might be in real life. Being able to use that nickname to try and drill down and find, it can be a caption in a group photo, or it could be somebody they may actually use as their username, that sort of thing. Getting a list of friends, getting the ability to even drill down and look to see what locations maybe people have taken photos in the past. All of that can be really helpful in guiding our investigators to try and figure out who else might be involved in the file.
Okay, so now with regards to that, so really open source intelligence is playing a role in a wide variety of types of investigations, nothing to do with computers or tech crime or even an investigation that started with something like social media, but this is important, is what you're saying. Would you suggest that it's something that is done almost routinely now in just about every investigation of this type?
In our organization, we're being tasked increasingly to incorporate open source information to try and bolster up other aspects of an investigation. It can be anything from a missing person to a protest that might be being planned that we're worried that might be violent, that sort of thing. If we can give a heads up on who might be involved in any kind of event along those lines, whether it be something as serious as a murder, or as something as somebody got beat up at a party, and we're now looking to see if anybody has video of that event.
Right, exactly. Now, I think it's important that one of the things we always say is to go back to the basics. As you are conducting your online investigation, go back to the basics. And in this case, what we're going to do is we're going to go back to the whys, the hows, the whats, the who's, the wheres, all of those sorts of things. So maybe you can sort of walk us through this a little bit, and let's say starting off with the why you're conducting an investigation in the first place.
I think this is probably one of the most important questions that you're going to be able to answer if you go to court when you're talking about your open source research, is why you were on this person's account, why you were searching for this information, especially because it informs the defense of what your instructions were given. So did the investigator tell you to look up this person? Did you find this person through other means? How and why? Why are you looking at this information? And the directions you're given by an investigator or by your boss when you're collecting that information is something that's going to come up when you're on the stand. Why did you examine the profile of my client? Why is it that this came to your attention? All of that is a question that you are probably going to have to answer. So to have that well documented before you even start your research is something that can help guide you as you do your research, and also help you articulate in court why you were doing the research in the first place.
So as we all went through in my early days of police training, constantly having it drilled into me, taking copious notes is what is essential here. And you can never really over notate something. Would you suggest that's exactly the same then when you're doing online intelligence?
Definitely. I find you can get pulled down into the rabbit hole. So it's very important to document where you're finding information and looking at making sure that you're keeping on track of what you were originally tasked with and not getting sidetracked. So yes, note-taking 100% is something that I'm going to highly suggest and recommend. If you don't have that requirement within your organization, I highly recommend that you do it for your own sanity. There's nothing worse than being pulled onto a stand 8 years. I think I've waited once 8 years. I got pulled into a stand on a file, and 8 years ago you did this. Why? So being able to have those really great notes to help you is important.
Tell me a little bit about the how then. So we've gone from the why, so tell me about the how.
Well, how is important because you gotta make sure you've documented your information in a way that the courts are going to accept. So in Canada, we have the Canada Evidence Act. I'm sure all the other countries that are represented on here today, you all have your own pieces of legislation of how information is considered eligible to be brought into court as evidence. So how you collect your information can be important. And in Canada, we've actually had case law and rulings talking about how are you capturing this information? Are you using screen grabs, printing can sometimes skew what you see. So what I print isn't necessarily what you see on the page. And really what the courts want is, what did you see as an investigator? So having you print it and then suddenly the banners cover half of the advertisement, banners might cover half of a comment, or the picture might get cropped off when you print it. So there's a variety of different ways that you can use different software, such as Hunchly. Hunchly has been actually mentioned in some of our case law. There's other screen grab software that's available. Just make sure that whatever you choose to use is something your company has agreed to let you use. I recommend paying for it, getting the licensed version of it. We've had analysts in the past in Canada who've been asked, well, why weren't you using a licensed copy of this software? So having the licensed software of whatever your organization or your country considers. One nice thing is you can search. You can look on Kenlee, Canlii, or Worldly, Worldlii, and you can search to see what other software people are using. So you don't have to reinvent the wheel. You can see if there's any case law involving some of the software that has previously been accepted.
And I think that's a really important point, because what may be very good for something like intelligence collection, the process of presenting as evidence is something entirely different. I mean, one of the tools that I really like using for intelligence purposes is Zotero, which is freely available. I like to describe it as bookmarks on steroids. It allows you to save copies of the pages and make notations, but it may not render the page exactly as it appeared when it came up on the website. And I think this is important as well, to make sure that what you are presenting in court is as it showed up on the website. One of the questions that caught me off guard that I was asked once was, yes or no, could this web page have looked different if you viewed it through a different IP address? Well, I had to answer yes under those circumstances. Now, the corner of my eye, I noticed a few eyebrows in the jury box go up. And I think this was important. The defense counsel doing a good job trying to create that reasonable doubt. You know, this is the kind of thing that can kind of catch you if you're not careful. When you've got, if you're presenting criminal evidence and you have a sharp defense counsel, that might be exactly the sort of thing they're going to pick up on to create that reasonable doubt.
Yes.
One of the things that I will point out here to our attendees today is, if you do have questions, please use the Q&A feature. I noticed that we've got about 68% of people who have not submitted, who have been here today, who've not submitted evidence in court. And it looks like those that have, it's been mostly criminal. So if you do have questions, please make sure that you use the Q&A feature. And then what we'll do is I'll take a look at those and we'll pass those questions on to Julie as well. Now, when it comes to expectation of privacy, I mean, let's talk about, for example, Facebook and collecting things off Facebook. And here in Canada, we have sort of a very important case, the Hamden case, in which information was captured off of Facebook. Not everything was there, and then that created an argument for defense counsel. Maybe you can just talk a little bit about that case and the importance of that and what's been learned from that as well.
Yes, actually, RV Hamden, HAMDAMN. We'll put it. Hopefully, we can put it in the link in the YouTube video once it gets uploaded. It's a really great case law in Canada where the judge actually ruled that, okay, it doesn't look exactly the way that it would have looked if I had looked at it on the day that it was posted, but it's still evidence. This ruling, RV Hamden, is actually quoted really quite a bit within our legislation. It's a great read. RV Sampson in BC just in January 2020 this year actually cited this among other case law. So when you go through that file, you can actually see a lot of the questions. The judge was actually, they got questioned on source code. Did you capture the source code? Did you capture everything? So it will vary by your country and by what case law has obviously been implemented in your individual countries, which is why I recommend going on to Worldly randomly and just doing a search. Do a search for Instagram, do a search for Facebook, do a search for whatever platform you're collecting information from, and just see, maybe learn from the mistakes of other people. Like maybe there's things that other people have done, and we can maybe learn from those examples instead. So when you do a screen grab, for example, if you're using an account that is a police account, an account that you've set up as an empty account, you may want to vet that account information out of your documents when you submit them. That may or may not be allowed depending on your country. So all of these things it's something that you're going to have a good discussion with your legal department. You're going to have to do your own due diligence. Make sure I set up an alert whenever Facebook and privacy or Instagram privacy or case law, internet research, all of those. I set up Google alerts. So I get an email that says, hey, something new happened in the news today, just so I can try and keep myself up to date on that, so I can keep myself out of the hot seat. I don't like being in the hot seat. So
none of us do.
No.
A question that comes in here, and when we talk about the what's, which we're going to get to next, and this question comes from Jeanette, who says, when doing a screen capture of data on a web page, do you need to include the address bar and the entire page if the intended data is below the fold? So how important is it to get absolutely everything? This could be a pretty wide question. What are your thoughts on that, Julie?
Well, it's very interesting because one of those, if again, you're looking at Canadian case law, one instance, the analyst captured the post that was of interest and a comment made by the person of interest, but they didn't fully extend and expand all of the comments. So there was hundreds of comments on this page. And one of the things that they were asked on the stand is, well, how do you know that my esteemed client didn't recant? 14, 15 comments below that you didn't expand, they came back and said, oh, never mind, that's not what I mean, or that's, you've misquoted me, or anything like that. You by only selecting what you've seen and not fully expanding, you leave yourself open for those types of questions. Because in the end, the analyst is going to say, I don't know what the other 130 comments were. And this gets back to, I think the original reason was the investigator only asked me to capture these particular comments by this particular person. So that gets back to your why and documenting why you're doing it and the instructions that you had from your investigator to do it. I like to capture everything, but I'm also one of those hoarders that has so much information everywhere because I don't want to miss something important. I would recommend that you do capture everything just to save yourself that question on the stand of, well, are you sure that you've captured all of the information? Having it there is important. Full disclosure.
And another consideration as well in terms of capturing everything when you believe it may be important is the volatility of potentially online evidence as well. Just as quickly as it appeared, it can be taken down as well. So if you have captured it right away, then you're going to be covering yourself as well. So let's move on to the when now. So we've moved through the why, the how, the what, and then maybe tell me a little bit about the when. So when we start looking at the recency of something.
Well, that gets back to your comment, David, about things being deleted. People can choose to be friends with people one week and unfriend them the next week. They can have a party one weekend and suddenly they're no longer friends. They'll delete pictures. Boyfriend, girlfriends will break up. They'll delete their pictures off their account. So in the end, having the ability to say, this is exactly when I was on the site, this is when the information was captured, and documenting that is so important in the event that that person does turn around and decide, oh, you know, I don't want that information up anymore. That's an important thing to consider, is when you were asked to do it, when you did the captures, so that if you go to court and they say, well, that person took that down 2 days later, you have it. You have it still.
The who. Tell me about the who. And one of the things I always find interesting about when we talk about who someone is, I always believe in skepticism without cynicism, applying critical thinking every step of the way, thinking about your thinking while you're thinking it. And when you've been working really hard to find a very sort of under the radar social media account that might be linked to the person that you're investigating, you find it, and you're all over it immediately. And there's a lot of cognitive biases that start to kick in. And one of the things that I suggest is stopping, stepping back, and asking yourself some basic questions. How do I know this is actually this person? Could it be personation? Could it be that this account has been hacked by somebody else and things have been posted there in order to create a difficult situation for the person that I'm investigating? Tell me a little bit about the who's.
Yeah, so this is actually, if again, if you search through your case law, and I know especially in Canada, you're going to find people saying, well, my account was hacked, or that wasn't my account, that somebody stole my picture. That's something that has been mentioned within the case law. So really, your due diligence of how you've identified who this person is. Are you comparing their pictures with other sources? So your police arrest photos compared to your profile photos. I'm looking for vehicles in the background. Do they have a license plate on them that I can then try to extrapolate, or a vehicle type if I can't get the license? You're looking at friends, associations, schools, anything. You go as wide as you possibly can. We often find too that people have the account that their grandma gets to see, and then people have the account that their friends get to see. So you have to be really careful to make sure that you are casting your net wide, to make sure that you are getting all of the information that you can. And what's nice is that some people can be lazy. So they'll post a picture that they want to share with their grandma, but they also post it on their other one that they want to share with your friends. So now you've got a cross posting of a photo between two separate accounts. So there's a variety of ways that you can really drill down and try and make sure that you are capturing who you say you are. And as a side note to that, if you do end up going to Facebook or to any of these social media platforms and saying, I want this captured, I want this preserved as evidence, I want this information from Facebook, they're going to need to know exactly what account that is. So username is not necessarily the best thing that you're going to have to have. You have to dig into that source code and figure out the unique identifiers for that account, depending on whether it's Snapchat or Instagram or Facebook. All of them have these unique IDs that you have to make sure that you're grabbing the right piece of information. You're not grabbing a vanity name that they've put onto their account, that you actually do have who you think you have, so that when you submit that information to through an MLAT or through mutual legal agreement, or through other court processes to the companies, these social media companies, they know exactly who you want the information from. You're not having to try and guess. So.
Let's talk about MLATs, the Mutual Legal Assistance Treaties, for just a moment. And maybe you're in a jurisdiction where you're lucky enough to have a presence of Facebook so that you can serve local court orders, production orders, and so on onto Facebook within your jurisdiction. But when it gets into an MLAT, it can be tricky sometimes, to say the least. In your experience, how cooperative have you found, generally speaking, these companies to be in providing the information that you've wanted? And when it has been difficult, where is the difficulty often arisen?
I've been lucky or unlucky. I've been lucky enough that I haven't had to deal with a lot of the MLATs. A lot of our investigators deal with our local crowns, our local court officials, and that's something that they pursue. Facebook for law enforcement, I find, is very helpful, especially if you can show that there's imminent harm, that somebody is going to be hurt as a result of this, or that somebody who is of danger to public is involved in something, that they are very receptive. But again, they have to do their due diligence too. They don't want you going on a fishing hunt either. They do take privacy a lot more serious, especially in Canada. So different countries have different stipulations on privacy legislation. We have the Privacy Act in Canada, but that same protection for people doesn't exist in all different countries around the world. So what you get from Facebook might be very different based on what country you're even asking it from. But I find that for some of these platforms, and a lot of them are cross-owned now, they will actually help out law enforcement if they believe that somebody is in imminent danger. I think if it's something less than that, you are going to have to actually show them, give them an actual warrant to make sure that they provide the information, because they don't want to be breaching people's privacy rights either for a government that doesn't have right to have access to that information.
Right. So exigent circumstances, they're going to generally act very, very quickly to provide you with the assistance that you request.
I find that if you are, that Facebook is very reasonable. For example, I find that it varies. It varies by social platform. It varies by organization who's asking for the information. I think I can't answer that question really for everybody. But again, if somebody is being harmed, if there's a young girl that goes missing and we view she might be in harm's way, I think most social media accounts are not, they don't want to be on the front page of the media either, saying, oh, well, we asked Facebook and they said no, and now she's dead. They don't want that either. So again, it's a fine line. It's a balance that we try to have, and we don't want to appear like we're fishing for information. Because again, if you go to court with something that you fished for and that you didn't really have a legitimate reason to have it, you're going to get that information taken out of the court. They're not going to allow it if it's something that you've gained without your due diligence and ensuring that you've followed all the correct procedures to ensure that that information is captured in a legally relevant way.
Right. Let's a question's just come up here, which I think is a good one as well, and about the methodologies behind capturing what it is that you're seeing online and then presenting it to court. So one of the important things that I always suggest is first of all, what is the prosecution? What is their capacity and capability as far as formats go? It seems they really like PDFs for the most part. So to be able to save a web page as a PDF document, which means that you get it in long form. So that's one of the things that is worthy consideration. In the digital forensics world, one of the things that is done is creating a hash value. So the original data as it comes in, maybe it's a hard drive, maybe it's a device, that is hashed. And a hash value, which is a one-way encryption function, is then created to get that hash value, so that in terms of the integrity of that evidence, it can be stated when it gets to court that what is being presented in court, the hash value is the same, therefore you know that it is the same as when it was seized. Is there, when it comes to evidence that is sourced online, are you aware of anyone or have you any experience in creating a hash value of what it is that you're finding? Has that ever been a request of the court to go to that extra step to show that it's not been altered in some way?
Yeah, as far as the experience in Canada, a lot of it is, I know in Hamden, the case that we were talking about earlier, there were some questions raised because the information was saved in a variety of different formats, and it was saved by one person and then it was sent to somebody else and they saved it to something else, and it was saved on this hard drive and then turned around and saved on another hard drive. So there were some issues regarding that within that case file. In the end, the judge agreed to allow that information to come in, but very simply stated that this is not necessarily the best practice and this is not something that he would necessarily encourage for people. So generally for us, we capture our screen captures, save them. And then I would normally myself, I like to, when I write up a full report. So I don't like to just hand over screen captures to people. I want a full report of, again, getting back into the background. Why did they ask me for this? What did I use to capture the information? How is the information stored? All of that within a body of a report. And then I'm actually attaching the screen grabs, importing the screen grabs into that one report so that it's all together, so that when it goes forward for disclosure, it's all there in one report. That report gets PDF'd and it's all on its own document. And then the screen captures are given as additional pictures within. So it's the same thing as taking a picture of something at the roadside of a road. That sort of thing. You're still, it's a photograph and it's treated under the Canada Evidence Act. It has to be considered, I guess there'd be a preliminary, you can do a voir dire or a preliminary to determine that the information is acceptable to be entered into court. But generally, yeah, we just save it and then that it's saved on an unencrypted drive. And then that information is, I like to copy paste that right into a report and say that screen captures are available on the file. Yeah.
Julie, we're just going to be wrapping it up in just a moment here. So if there are any questions, please feel free to bring those in now. As we kind of wrap things up, we talk about case law, and you've mentioned Worldly and Kenlee. Tell us a little bit more about that and the kind of research that you can do on those websites.
Kenlee is the Canadian court rulings. So once you go onto Kenlee, you can search by person's name, for example, if you want to see if anybody has been in the courts previously, or you can search by topic name. If you do Facebook, I think you're going to get a bunch of divorces. If you do LinkedIn, you're going to get a bunch of people who have fraudulently gotten a job. So all of those types of searches are available. I know I found when I looked on Worldly, I did a search for LinkedIn, and I found an Australian judge who determined support payments based on the employment that he put on his LinkedIn account. So there's a variety of weird things that judges are doing, and it's always neat to be able to read through the different rulings. Kenlee also has commentary, so you can actually see people who will comb through and pull together a bunch of different cases that are interrelated, and they'll do a commentary on it as well, which I find is nice because you get that other perspective of somebody looking at it, a bigger picture, because that's what I like. So seeing somebody look at 5 or 6 different pieces of case law within the commentary on Kenlee is also really interesting.
Right, exactly. So even just going beyond entering people's names, entering that social media platform, and you're going to get
Yes,
case law around that platform. A
absolutely.
question has just come in here from Tom asking whether you've given evidence in civil cases, and if so, are the rules of admissibility as stringent, given that in criminal court it's got to be proven beyond a reasonable doubt. In civil court, it's a balance of probabilities. So maybe tell us a little bit about that.
Yeah, I would definitely think that, well, in Canada, you are going to see a much higher scrutiny, higher requirement for evidence within a criminal court. Within the civil case, I know that you're going to see, and Facebook, for example, if you do those queries for Facebook on Kenlee, you are going to see a lot of people who are doing divorces or disgruntled employees who've posted things on their employers' Facebook company pages and things along those lines. And there is a difference in the type and the way that they approach that information. My advice to you is assume that I would rather have it collected to a higher standard and know that I am not going to be in that hot seat than assume, oh, well, it's just civil, so I'll capture it. I don't need to be as stringent when I'm capturing it. I'd really rather err on that side of caution and put myself up to the highest standard possible, just so that I know that my information will be used within the proceedings.
So would you say it's being aware of what and why you're doing it and how you're doing it, taking copious notes, and anticipating the difficult questions that you're going to be asked? That's what all of this really comes down to.
Really, yes, exactly. If you can read through Hamden and see some of the questions that analyst was asked, that gives you an idea of some of the potential questions that could be faced or posed to you when you are in court. So whenever you review, R.V. Sampson in BC was another really great one because they talk a lot about all the different case law over the period during their voir dire of their information. So that was a really great one too, in the sense that you can see all the different questions that all the analysts before you have faced and give you a good idea of, well, I don't want to be asked that question on the stand, so what do I have to do to make sure I don't get asked that question? And keep yourself, it's a learning process. You're going to have to do it all the time. It's something that's ongoing. Like you said earlier, David, it changes. Everything gets updated, but that would be my advice. Go to a higher standard.
Right, exactly. Julie Tillotson, thank you so much for taking time out of what I understand for you right now is a very busy time. So we really appreciate you taking time out of your day to
Yes.
be here today. It's been fantastic having you. And thank you all of you for attending this webinar as well. Next week, we are going to be having a special guest from Mexico City, George Gelman. George is an expert in organized crime, among other things, an intelligence analyst himself in Mexico City. He's worked with various government agencies in Mexico as a consultant. And George is going to be talking to us, and it will not be recorded for YouTube as well. So you do need to attend live if you want to see this one. George is going to be talking about organized crime in Latin America and how they are coping with COVID-19. And some of the observations that George has might really surprise you as well. So if you want to find out about that and other drop-in and learn sessions, please visit us at dropinandlearn.org. And hopefully we'll see you back for some of the future webinars as well. So once again, thank you, Julie, and thank you for attending, and we'll see you next time.